podcast published by the Meritas EMEA Employment Group. Periodically, members of our practice group get together to discuss international, interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray-Hines, an employment lawyer at Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Ruta Globita from Wyden in Lithuania and Catherine McKinney from Martelli McKegg. Both are employment lawyers. Our discussion today is on platform workers and the gig economy. Now, to explain what a platform worker is, this is someone who provides services via digital platforms, so an app or a website, without being engaged under a traditional employment contract. This captures roles such as ride-hailing, drivers, couriers, and other on-demand service providers. Now, the UK continues to operate a three-tier employment status system where we have employees, workers, and self-employed individuals. And most platform workers tend to fall between the last two categories, with disputes hinging on factors such as control, personal service, integration, and economic dependency. This ambiguity has driven litigation, with high-profile cases involving Uber and Deliveroo, to name but two. And I think it's fair to say that there's an increasing recognition that the UK's current framework struggles to accommodate the realities of platform work. And there is also external influence from other jurisdictions. The Platform Workers Directive came into force on the 1st of December 2024 for member states and introduces the first EU-wide framework aimed at improving working conditions in the platform economy. Member states need to have implemented the directive by the 2nd of December 26. Although the UK is no longer part of the EU, this directive affects the UK companies who are operating across Europe or using large-scale platform workforces. The directive is also likely to indirectly shape domestic debate and corporate compliance strategies. As member states retain discretion on the exact criteria for determining employment status, this means global businesses may face varying national approaches. So Ruta, this is a great point to welcome you to the podcast. From a client's perspective, what do they need to know about developing European case law in this area and also the impact of the EU Platform Worker Directive?
Hi, Sam. Thank you so much for the question. The EU Platform Work Directive aims to grant platform workers, for example, like you mentioned, those working through apps like Uber or Deliveroo, better legal protections, including clear classification of their employment status, access to the social security system, and transparency about their working conditions. So it introduces criteria to determine whether platform workers should be classified as employees or independent contractors based on how much control the platform exercises over the worker, and that's the key. The classification impacts workers' rights to benefit like sick pay or holiday leave, and this used to be the main issue here. That's why we do have now the directive in place. For example, you mentioned that in UK you have three categories. Here, for example, in Lithuania, we do have only two. You either an employee or a self-employed person. So this is why it's very important for EU member states to adopt the directive as quickly as possible for classifying the persons. Developing the case law, answering to your questions, will be key in shaping the implementation of the directive. National courts, including the Court of Justice of the European Union, will play a major role, to my opinion, in interpreting and enforcing the directive's provisions. Employers should stay updated on the case law, as decisions can influence the obligations and the classification of the platform workers in the operations, because the directive says that member states should either have the law or the case law which may help to classify whether it's service which are provided by the self-employed person, or we are talking about the employee who is employed under the employment contract. So clients should review and possibly update worker contracts, assess worker classifications, and ensure compliance with the new standards to avoid potential legal risk and, of course, financial risk, such as back payments or reclassification claims if employees would go to the labor disputes asking to reclassify them from the self-employed persons to the employees. So they should also be prepared for the potential challenges and claims from platform workers who may seek compensation or dispute their classification.
Thanks. Am I right in thinking as well that the directive has a legal presumption that these platform workers are employees unless the person engaging them can prove otherwise? Is that correct?
Yes, yes, that's correct.
Okay, thank you. Moving over to you, Catherine, welcome to the podcast. And thank you so much for accommodating the time zone issues from New Zealand. Could you talk to us a bit about the position that's developing in New Zealand? So do you have main legal tests there about determining whether someone's an employee or genuinely self-employed? And how are the New Zealand courts approaching these cases?
Yeah, we do. And, you know, a lot of the principles are actually quite similar to the UK when I practiced there quite some time ago now. But the devil's in the detail. And it is really interesting to hear about your developments in Europe in relation to case law and directives, because we also have sort of two parallel case law and new legislation potentially coming in here as well. So just at the end of last year, we had a really significant case in New Zealand that went all the way to the Supreme Court, and that involved 4 Uber drivers challenging whether they were employees instead of contractors. And in New Zealand, and the Supreme Court held that they were in fact employees. And on the way up through the different courts, the tests swung around a little. But actually, what the Supreme Court did was basically landed on the traditional approach that we had in New Zealand, which was to go back to look at what the Employment Relations Act here says, which is the real nature of the relationship. And that is based on those tests that sound very familiar to you, I think, which is the control test, the integration test, and the economic test. And what was really interesting was that although the workers, the Uber, we only have the 2 classifications here in New Zealand as well. And so what the court said was basically there was a very high degree of integration, which may be a surprise because in the old traditional sense, integration was more about wearing uniforms, you know, turning up to premises on time. But actually in the Uber case, what they said was there was a high level of integration because of the systems that were in place that the Uber drivers had to comply with, and the fact, so effectively, in that traditional sense, they had no ability to build their own business, which is that economic test, and also there was a high level of codependency, and that although, you know, they used their own cars and they chose when to work, they didn't have a say about the quantity or quality of work or the price that's paid for it. So the Supreme Court have landed back almost onto those traditional tests. But interestingly, at the same time, all year last year, we've had this bill progressing through Parliament, which basically is aimed at creating more certainty for contractors about what their status is, for employers too. And it's called the Gateway Test, and it basically sets out 5 requirements that if this passes into legislation will create a gateway through which individuals would have to pass in order to be confirmed as contractors. And those tests, again, they're kind of common sense tests, but they're going to take a lot of sectors by surprise in New Zealand. So they are things like, maybe perhaps the obvious things are that there has to be a written agreement that identifies it as a contractor agreement, rather, you know, that's an obvious one. But then we have things like the contractor would not be restricted for performing work for others. That would catch a lot of people out in New Zealand who are classified as contractors. And they're not required to be available at specific times, or they can subcontract the work to a third party. The arrangement wouldn't be terminated if they went and worked for others and worked, you know, weren't required to work additional hours. And also a key thing as well is that they were invited to go and get legal advice before signing an agreement. So those 5 tests haven't come into law yet in New Zealand. So at the moment, we've got the Supreme Court decision, and that's what we're basing it on. But we are expecting this. It's passed through the Select Committee, and it's about to have its 3rd reading. So we are expecting this gateway test to come in really quite soon. And so we're going to be looking at a new regime.
Yeah, it's quite interesting, and there are a lot of similarities across the jurisdictions. And these kind of tests that are coming in now to try and give some clarity around the position. I think it's more difficult in the UK because we like to make things more difficult with having the 3 different classifications. But it's interesting the point around people who are working on the apps and the point at which they're kind of logging into those apps, and then they're kind of more under the control and the kind of penalties on them if they sort of don't take certain rides. We're talking about the Uber drivers. So there's a lot of sort of similar case law going on in different jurisdictions with very similar outcomes as well. So it'd be interesting to see how this continues to develop. And it's a question now for both of you. Ruta first. Are there any red flags in this kind of platform design that clients should be aware of and really reviewing? I know you mentioned a few when you answered the first question, but are there sort of features of these kind of platform models that are most often triggering this kind of reclassification?
Yeah, Sam, thank you. So the clients, I do believe, should be aware of key red flags in platform design that could trigger successful reclassification claims, for example, particularly if the platform exerts significant control over workers, schedule tasks, for example, or income, provides essential tools or equipment, imposes penalties or disciplinary measures, or restricts, for example, workers from subcontracting or working for others. That's also the key. Features such as these can blur the line between independent contractor or employee status and potential leading to the claims for misclassification, I believe. To mitigate risk, clients should review contracts, first of all, to ensure clarity in worker autonomy, avoid excessive control, and ensure workers maintain flexibility typical of independent contractors while remaining transparent about the rights and obligations to prevent legal challenges. But the contract is one thing. Of course, factual situation is also very important. How much the platform has control? Is there a possibility for the platform to suspend, for example, the contractor for providing services, and so on and so forth? So we also need to take a very good look on how the app works itself. For example, in Lithuania, as I mentioned before, we have a gray area here. We have very limited specific case law on how employees are classified, self-employed persons are classified to the employees, but mainly there is a great area between individual activity and self-employment. So we have lots of attention now because we need to implement directive into our national legal system. And as far as I took a good look to the projects of the specific laws will be adopted at the end of the year, we probably here in Lithuania will have several different criteria in order for the courts, for example, or the labor commissions, because we do have one of those to classify self-employed relations to the employment relations specifically for platform workers. So I do believe we're gonna have the case law further in the future, but at the very beginning probably is gonna be several criteria which leads for classification. So also clients should follow the case law, should follow the law, start with reviewing the worker contracts, and of course making sure that there is very less control over the contractor.
And same question to you, Catherine. I could see you nodding a lot there. I'm taking it. It's very similar in New Zealand.
A lot of similarity actually. It's so interesting because we are also just, we have this new case, and that's very informative, but it really is just that one case in relation to Uber. And there are so many other platforms around food delivery and everything else. So we are also really quite in our infancy in terms of the case law that we will inevitably now see, I think. But we are not yet really able to advise clients about what steps they should be taking right now, because we've got this gateway test, which, you know, is sort of imminently coming. And I wouldn't be surprised if it was added to before it comes in, which somehow brings into play the platform aspect. I'd be really surprised if they didn't do that, because now we have the Supreme Court ruling. There's some really good guidance for that bill. So, and I do think that the bill might have been slowed down at select committee stage because the Uber case was being decided. So I think we're going to see some change. But for now, the red flags are definitely around how the app assigns the work and the control that it has over the individual. And they're basically, it goes really back to that fundamental economic test. Can that individual have control over the price, the job, and whether they can earn a living outside of doing that work? So those are the key things that if we were looking at contract agreements now, I would be focusing on.
Okay, so it sounds like the key takeaway from clients for this episode today is basically looking at the arrangements they've got in place, looking at the contracts, looking at what's happening in practice, and trying to sort of mitigate against a reclassification claim or challenge, and keeping an eye also on the developing case law, and keeping in touch with your Meritas contacts, of course. So that brings us to the end of our episode today, but if any of our listeners have any questions, please do get in touch with your local Meritas firm, or if you'd like to find out more about Meritas, you can do so via the website meritas.org. And that just leaves me to thank our guests today, Ruta and Catherine, and we hope that you'll tune in next time. Bye for now.